Hello, and welcome to Truth and Transparency. Pardon the interruption. Again, welcome. This is the episode 2, part 2 of the defense's closing. And I'm going to just play this with a little bit of admin here and there. So again, this is going to be closing out Lindsay's defense team, and then prosecution does the rebuttal. But let's finish this up so that we can get into Jason's testimony tomorrow. Again, welcome. This is going to be Lindsay Partin's episode 2, part 2. This is to close out the defenses. So this is just getting through some important stuff so that we can get to more important stuff. Here you go.
But I submit to you, and the police have the power to get that, and they didn't. What they do have is Lindsay Partin's cell phone. And the reason she wouldn't submit to what Detective Whitlock said is because right then and there, she knew that that timing didn't sound right to her. As you know, I'm not much of a computer person, so I'm not going to flash up stuff on the screen except for things I might type up or write on a sticky note. I got hot notes. 6:52 to 17 a.m. Text to Jason. Jason to Lindsay. Apologize. Getting ready to head over. That's at page 4609 of the extraction. 6:52 and 55 seconds. A text from Lindsay to Jason. Okay. Again, page 4609 of the extraction. 7 o'clock and 47 seconds. An outgoing call, Lindsay to Jason, page 98 of the extraction. 7:01 and 24 seconds. Incoming call, Jason to Lindsay, page 98 of the extraction. And the duration of that call was 15 seconds. 7:02:51, outgoing call, Lindsay to 911, page 98 of the extraction. And the duration of that is 13 minutes and 22 seconds. This is the timeline we know. This is the timeline that isn't dependent upon ICE or how long.
Okay, guys, this is really important. I'm all about timelines. So here we go. 6:52 a.m., 17 seconds. Text Jason to Lindsay saying, getting ready to head over. As you can see, 6:52 and 55 seconds, Lindsay says to Jason, okay. Something that the defense didn't do that they should have was say, well, clearly you weren't at the house by that time because Lindsay says, okay, you know what I mean? You wouldn't text him, okay, after the fact. But that's where my logic is just amazing. But this is important because they say that this all happened. So I want us to listen to this, and then when you hear Jason's testimony, which is coming right after this, and then we're going in from the beginning at that point. This makes everything different.
It takes someone to get a kid out of their house, to get them over to the neighbors, how long it takes you to put on your boots or coat. That's what we have. That's what we have evidence of. True, hard evidence, which the detectives tried to get her not to believe. And Lindsay said, that's not true, and she showed them. I submit to you that Lindsay Partin had this child 1 minute, maybe 30 seconds, and Jason Wesche agreed with me when I went through the timeline with him. He said it was about 6:55, finally said it was about 6:55 when he got out the door, because he said that to several people. So he now knows, by the time he testifies, how important the timeline is. Because the longer he has Hannah over at Lindsay's house, and Lindsay's got her, then his patsy really did work. He finally agreed with me that it would take him about a minute to get from his, after 6:55, to get from the front door to the car, go around the car. He didn't want to agree with me, but you got to get around the car to get in the driver's side when you park front end. About a minute for that to get in the car. He didn't want to agree with me in regards to the windshield or anything like that, but ice and snow on the ground, that car, unless it's been out late at night, that car would be frosted up, unless he'd been out late at night.
Oh, sorry. Oh, sorry.
A lot later. Really late. Then about another minute to get to Lindsay's. Then they chit chat about another minute. 6:59. 6:59. Seven o'clock and 47 seconds.
Oh my God.
Hour.
I just seriously, oh my God, I just seriously talked for 5 minutes. Didn't even realize that I was on mute. Bless us all for these gifts. Bless us all.
But what else do we know?
Okay. What I had said before, which nobody heard, is that timelines are everything to me. And what the defense is showing here was the timeline that Jason had texted, said he was getting ready to head over. Then they were showing the distance between the houses, which is like he lives like where they live, so it's like on the same complex. But by the time he was to get in his car, then we're going to get into all this stuff, but at the end of the day, literally the defense is going to say here that, Lindsay had Hannah for like a minute, possibly more, like by another minute. And then what do you think she did? She just started beating the shit out of this child? Like, what are you talking about? Type of stuff. Like, but I just talked to myself for about a good 5 minutes, so I can't even, like, my voice needs a break. But I love you, Boston.
Jason's heard on the 911 call at the beginning. Lindsay tells the dispatcher that her dad is there, and Jason agreed that he had gotten back to the house, assessed his child, picked her up, and put her on the couch in the garage. So 1 minute, 27 seconds from the time he calls her back at 7:01:24. There's 1 minute, 27 seconds to the time of the 911 call. So in 1 minute, 27 seconds, Jason Weishe has gotten the call, turned around. I submit you turned around is the right word. He didn't get down to that shop. He didn't make the truck running down to the shop. That's implausible. 1 minute, 27 seconds sure is plausible that he turned the car around, drive back up the road with his frosty windows, park his car, get inside the house, and assess. But even more so, you've got the duration of the call. So it's not 1 minute, 27 seconds, it's 1 minute, 13 seconds. 1 minute and 13 seconds.
This is good, because I get to get into the Jason live. After that. Did you blow this up in here? Wait, you can blow that up.
This is 1 minute, 27 seconds.
Come on. Let's get it on. Come on, get it on. This is the end of the closing arguments for the defense. But wait till you hear Jason's testimony. You guys are about to lose yo dicks. I said it. Miss Marple, that was like one of the first cases I watched. Watch this, here we go.
And that's in addition to opening up the phone, putting in your code or your thumb, and getting the call made. So add that time in there. And you're panicked. Are you really telling me that he was down at the shop? I think not. I submit to you that the evidence shows that he barely left the house, just like Lindsay said. The phone is verifiable. Jason Weshy is late that day, by all accounts. And what do we know about that? He admitted he was on a short leash at his job. He told you that at Smith Court, it was probably a yes answer to my question. At Smith Court, you're late if you're there at 7. And he was told that 2 days prior that he better get his act together or he's gone. And if he's gone, he's renting his house from his boss, he's buying his car from his boss, and his babysitter is the boss's daughter-in-law. So everything's gone. It's important for him to be on time on that day. So when the prosecutor talks about, oh, Lindsay and her husband were arguing and she'd had a miscarriage a month before, by the way, and she's just not in her right mind, let's really put it squarely where it goes. It goes squarely at Jason Weshy. Remember how Mr. Pagan told you in voir dire, when, that was, gosh, days ago now, voir dire, that we don't have a burden of proof as the defense, and our client is presumed innocent, because that's what our standard of law is. It's one of the best ones ever. And it's that way because otherwise the innocent people would be in prison, in jail, convicted. Lindsay Partin is innocent. I will tell you she's guilty of being stupid, really stupid, and trusting. But that's not finding her guilty of this criminal offense, these heinous criminal offenses, because that's what they're saying she did. I'm going to go through some of the stuff that the prosecutor said in her beginning opening. She talked about how Lindsay on her video statement said, oh, it was the right eye or the left eye. My own daughter, she's only 14, can't figure out right and left. She said she remembered a little hickey, and you can see from the photographs that the only little hickey spot is on the left eye. That doesn't mean anything. Said she had no emotion when shown the photographs. I don't think that's true. She certainly wasn't looking at them. She was told what was on them. And she asked about, what are these bruises? Try to explain these bruises. And she gave the best explanation she could, because she told you that she saw the scratch, the abrasion. I don't remember what side it's on. I think it's on this side. The abrasion. And it's not until the next day on her first potty that she says, oh gosh, that looks a little bit worse. And then what does she do? She searches. She does a Google search. And the Google search, contrary to what the prosecutor said, is not at 4 o'clock. It's not after the train incident. And 4 o'clock's pretty clear. Her statement all along is the choo-choo train falling happened at 4 o'clock. 4 o'clock, multiple times. The how to get rid of a bruise is on the 7th at 8:48 and 17 seconds in the morning.
So right there, they lie about the bruise.
She lie about the bruise. A lot more bruise than it was before. So she searches. And then the next 2 times she searches for something like that is in the afternoon while the kids are napping. So this isn't related to the train incident, this is related to the bruising, which she thought looked pretty awful. Jason told her about those 2 long handles. But that's not how she left the day before. And Lindsay the Patsy was like, yeah, I guess that's from that. That's what that must be from. Maybe if she lifted her shirt and saw everything else. Maybe if she checked her whole body like her father, she'd have seen everything else, but she didn't. And the prosecutor made mention of that she didn't exactly word for word tell the police what the search was. She changed it both times. Well, then, was that important? The exact words you used for the search? I submit to you, you do a search for something. Do you remember the exact wording you always used? I've done lots of searches. Law searches, looking for hotels, looking for places to go. I don't remember the exact words I used. I remember the context, I'm thinking about, the context. And she told them that. And the prosecutor wants to point to the deletion of that search. I submit to you that the deletion of the search means nothing. If it meant something, we'd see a yes next to line 3, which is vapor rub good for bruises? And line 4, what essential oil is good for bruises? Then it means something. And of the 33,000 pages, that's the page. This is their smoking gun. This page, taken out of context.
They never got
Not all
the.
these other pages with
This
yeses
is telling them they
undeleted.
never got the phone
They mean
records.
nothing. Deleting USPS
Jason,
tracking, deleting
30,000
hair color
pages
searches,
of
deleting
phone
looking for a
records, they got
hotel
it.
in Houston Woods or something like that. Lots of inane things. That's not a smoking gun. That's their circumstantial evidence, but I submit that you all are smarter than that. C-collar. So EMT Reedy told you that they didn't put a C-collar on her and they didn't intubate you. But what I also heard from the first doctor at Fort Hamilton Hughes was that he immediately believed this child needed to be intubated, and he immediately put a C-collar on her. Is that important? I don't know. I'm not a doctor. Could it have caused other injury? I don't know. But it's something that the prosecutor wants to talk about that says, oh gosh, she was injured more. How do we not know that she wasn't injured more, that the EMT scooped her up, carried her out to the cot? Is that why her levels changed? Is that why she needed intubated when she got to Fort Hamilton? The prosecutor will say, oh gosh, Lindsay Partin has bias and interest in a finding of not guilty. I'll give him that one. Lindsay Partin is innocent of this crime, and she obviously has bias and interest, as anyone would. She told them what they wanted to hear. She gave them her phone. She gave them full access to the house. The only thing they have is her statement. That's what they have. And I'm not saying it's a good statement, but she explained exactly how that happened, and it sure does meet with the aneurysm, doesn't it? When you go back into the jury room, you have 12 people. You all have an individual verdict because your verdict has to be unanimous. And the jury forms are complicated, and I'm going to get into the law just a little bit here. The jury forms are complicated. But if you believe something different than the person in front of you or beside you, you have your decision. The judge is going to tell you that you need a unanimous decision to make any finding, but your decision is your decision. It's not just getting along. It's not just needing to find somebody, needing to mark the box, because this is the most important affairs of your life that this case is about, that you have to make your decisions about. Would this case be State of Ohio versus Chris Davis? I don't know. It could be. I don't know enough about that, and the State of Ohio doesn't either.
Chris Davis is
Reasonable doubt exists in the medical evidence, timing evidence, the confession, and the history provided. And I'll just circle back on the confession just a little bit. It doesn't meet the medical evidence in this case. They want it to, but there's no blunt impact. She didn't say anything about a blunt impact. Based upon the evidence you heard during this trial, let me tell you some reasonable doubts. The blunt force injury happened the day before. Anytime the day before. The evening of the 7th. You've got lots of hours there. The blunt force injury was caused by Jason Wesche, Chris Davis, or someone else while they were out on the evening of the 7th, because the history is all provided by Jason. She fell on the ice. She fell in the back seat. He's in a hurry. Chris Davis poked her. Is it plausible or probable that the injuries to the chin are from the gravel? The abrasion looks like gravel. What's the rest of it look like? And if Dad saw this and saw this, and he didn't think that Lindsay had done it, he needs to be there. And those bruises are of multiple colors. And he would be livid if he didn't do it when she comes down to Children's Hospital and sits for 4 hours, even if she sat for 10 seconds. I'm going to go over the law just a little bit and then finish up a couple other things. So Ms. Sheehan went through a couple issues. Count 1 has a lesser included offense, and the judge will instruct you about those. So count 1 is recklessly, so number 1 and number 2, you can probably just stop even looking at those numbers. Number 3 is pretty important. I submit to you, not guilty is the evidence, that is not Lindsay Partin. Did someone recklessly torture or cruelly abuse a child? It's not number 3. Judge will define those terms for you, the term recklessly. Judge will define the word torture for you, the word cruelly, and the word abuse. And the prosecutor will probably get up here and say what she said, she thought she could slap her. She said that, yeah, she told you she thought somebody was going to back her up. Because she's not a very smart woman on that one. After the fact, it's pretty clear why aneurysm was brought up. Because it sure did take Lindsay off the scent. Because then it wasn't her or him, it was just an aneurysm. The lesser included offense on that. Recklessly abused a child. I
The
submit
police
that
told
you will return a not guilty verdict on
Lindsay
count 1.
that Hannah died
Count 2,
before
also
she
for that
did.
same date. And the judge will define the extra terms here that are a little bit different. Same dates, 6th to the 7th, same county, obviously. Again, I submit to you, you will not find number 3. And you'll return a not guilty verdict on that. Count 3 is a little tricky in terms of some legal definitions. And the
Right
judge will
now,
give
she's
you all
just
of
going
these.
over like the counts that the judge told them that Lindsay Partin's up for. And I'm about to
March
end this
8th,
here. and
Butler County.
I'm about to go into Jason's interview.
I submit to you, the evidence will not show number 3. The judge also submits what's called a special finding, and you'll get an instruction on that in order to make an extra finding on that particular verdict form. I submit to you that your verdict on this count will be not guilty. That is what the evidence shows. I think I'm on count 5. No, I skipped over count 4, I'm sorry. Count 4, involuntary manslaughter. So up until count 3, all the counts have been about child endangering with various ways in which to charge it, with different elements, and each of them had a little bit different, and they all have an instruction as to how to define these terms. I'm not gonna go over those because the judge is gonna read them to you and give you all a copy. But I submit to you, the evidence will show that that is not Lindsay. The medical evidence doesn't show it. The timing evidence doesn't show it. The statement doesn't show it. And the history provided by father doesn't show it. Count 5 is another child endangering for the 8th. So you have 2 charges of child endangering for the 8th associated with 2 different ways for the death. I'm sorry, I'm going to go back to the involuntary manslaughter. There's special things that you have to find on that. I'll come back to it. Count 5. Endangering children. I submit to you that the evidence will not show 3. There's 0 evidence of that. And the prosecutor will say, well, you know, she said she shook her. And one of the doctors said that that's possibly what it is. Well,
We're going to be finishing up here with the
brain swelling.
defense's closing.
No skull fracture.
There is
Those
a
injuries
quick rebuttal
that
by
connotate
the prosecution
brain swelling and therefore unconsciousness.
on the closing.
And I asked you to go back
But
to the
the most
definition
important,
of
I think, testimony
beyond a
is
reasonable doubt
Jason's.
and what
And that's going to actually be coming up next, which will be tomorrow morning.
It's probably and possibly.
After
And those are not sufficient in a legal term.
We're going to close it up here once this
Count
ends.
6. Murder. Which means she didn't cause it either, and she didn't recklessly. So when I've crossed out the third element in each of those, I'm saying no on the others. She didn't cause the death. She didn't. We don't dispute that Hannah died. I wish we were in a different spot.
Again, the biggest part of this case is that the prosecution wants you to
No
believe
doctor identified a mechanism of injury
that
within a reasonable degree of medical certainty, which is far below the beyond a reasonable doubt.
it's because they want you to believe that
the doctor
Hannah was basically
would commit to a
shook
unit of time.
/ struck right after her dad dropped her off in the
Dr.
morning.
Macroff's testimony
And
about
that's
the
just
hepatitis
what
C
they're trying to prove is not
is that,
possible.
oh, she didn't see it in the pediatrician's records. And then she said, well, it wouldn't cause, that's how she phrased it. Hepatitis C wouldn't cause the bruising. Well, that wasn't what was being asked about. She admitted that hepatitis C does result in more easily to be bruised. I think she thought we were trying to say that the bruising on this child was caused because she had hepatitis C. Well, that's just ludicrous. Come on. The potentially is not proof beyond a reasonable doubt. Ms. Sheehan said, oh, I bet Dr. Spitz didn't read the 5,000 pages. Sure doesn't look like he reads 5,000 pages. It's probably why his eyes can't read good words, but he knows medicine. And I think Dr. Macroff was asked about those 5,000 pages, and she basically said, I don't read all of them. Dr. Correa said, my opinion is not offered as to who. My opinion does not extend to the mechanism of injury, only that it's traumatic brain injury. This is not a red herring or a smoke screen, as prosecutors like to get up second, because they get to go again. After I get done talking, they get to talk again, and that's because they bear the burden of proof. So if you think I took a long time, I apologize. I'm taking the time that I think is needed, because I don't get to talk again. Sergeant Whitlock said on the first interview, I don't put innocent people in jail. Lindsey Partin is innocent. Look at the evidence, you'll see that too. And Whitlock handed this case off to Detective Turner. The two different theories on March 8th in the state saying we don't know happened.
Okay,
They're
this
held
is
to a
Lindsey
burden of
Partin's
proof.
defense. She's closing out her long, exhausted.
I know you won't forget that.
2 hours she talked.
The prosecutor said, the defense attorney is trying to attempt to insert doubt. I literally.
Okay. I mean, that's a long time. 2 hours is a long time to talk. So, yeah, 9:30. I got my West Coast people tuning in. That's awesome. So that is going to be Lindsey Partin's defense attorney closing it out. Now, I've taken my notes. I've done my due diligence with a couple different things. But now I am turning to you guys here because the most important testimony I believe that takes place is Jason, Hannah's father. And I think the defense attorney does a great job on the cross-examination. But the world thinks that the defense attorney bullied Hannah's father. I saw the frustrations with the defense attorney saying, why did the state zero in on Lindsey? Why didn't the state, question Jason, get his phone records, do this, do that? You're going to hear all about what went on. And that's actually where we head next, which is Jason's, direct examination, and then his cross, and then his redirect. So that's where we're going to be heading next. So all I can urge people to do is that if you want to catch up on this case and the family that I'm helping here, is to take the time if you would like. I'm working backwards in a sense, that I played the prosecutions and then the defense's closing. And it was only to help people understand what this case was about. Usually in a closing, a lot of summarizing goes on. And so at this point, I will then be moving forward with starting then from a couple of different people's testimonies in the order that they were given. But I'm going to do Jason's first and then the rest in the order that they were given. After we get through the next 4 or 5 days, then I will be getting into my investigation, and I will be showing you guys my investigation. So basically, I'll be summarizing what the defense said, what the prosecution said, before I start Jason's episode tomorrow. And I'll be going into the areas that nobody else did, which is, did they talk to this person? Did they talk to that person? Why wasn't this person called to the stand? Why wasn't this person, stuff like that. But it's my job to find new evidence to get Lindsay Partin back into the courtroom. Unfortunately, Lindsay does not have the ability to do ineffective counsel. She's exhausted a lot of her options, and now we're looking at, if you can find new evidence, you can be granted a new trial. That's where we're at with Lindsay. I think that new evidence is possible. And but those of you guys that are following along, I just want you guys to know what you're following along to. So take the time to, double check on, if you want to, the closing from the prosecution, this closing from the defense, and then join me live tomorrow. We'll have a lot of interaction with Jason, her, Hannah's father's testimony. And a lot of the photographs that are shown are of his home. And it is just astounding. Like, it's just mind-blowing to me that this jury found Lindsay Partin guilty of murder. We're talking about murder. That means, you know what murder means? Premeditated, planned murder. So yeah, joining back tomorrow. Again, thank you guys all for joining me this evening for this little nightcap, but as well as all my other lives. I do appreciate you guys. Be kind and chat love, and we'll see you soon.